Okay, thanks for coming. You probably noticed that I'm not Joe Hall. Joe was actually injured in a car accident, so he was unable to join us today. So definitely send your thoughts to Joe. But in the meantime, I'm filling in, pinch hitting, as it were, on a different topic, which is basically the FCC's new rules on ISPs and consumer privacy, which were released last week. So what I'm going to do basically is give a little bit of context for where these rules came from, as well as a little bit of background on the rulemaking process. Then I'll talk a little bit about just the process by which the rulemaking played out and where I provided input in various places into the rulemaking process, and Arvin and Dylan also provided input in various places as well. So I might call on them at some point during this discussion. Then I'll talk about some of the outcomes. The rule was actually just released less than a week ago, so I'll talk a little bit about some of the things that came out of the rule, and I'll close maybe with some personal remarks on just my impressions of the whole process and some things that I learned. Okay, so let me start a little bit with context. The next couple slides actually are due to Jonathan Mayer. Actually has a really good hour-long lecture on this particular topic. But basically, the FCC actually has authority to make rules that, and I should have prefaced this with, I'm a computer scientist, not a lawyer, so I'm going to do my best here, but to convey my understanding of how this works. But effectively, the FCC has authority to make rules that have the force of law, unless they're challenged by a court or unless Congress does something to make a law that overrides one of these rules. So Congress is not doing anything these days, so it's a pretty interesting time for the FCC because pretty much whatever rules they're making that don't get challenged effectively have the force of law. And in the last couple of years, some really interesting developments have come about. Basically, and this is the background that he provides. The FCC has authorization to make rules or basically laws in certain parts of in certain jurisdictions, and we'll talk a little bit about that. Based on the authorization to make these rules, they will basically issue what's called a notice of proposed rulemaking, and this is basically an invitation for comment. So this goes into, basically anyone can comment. So I commented, Arvin commented, Comcast commented, the Federal Trade Commission commented, anyone can basically comment. After that, there's basically there's a period of reply, reply comments, and then sometime after that, there's a final rule that's basically issued. We're basically at this stage on this particular rule. At that point, there may be review by courts, potentially challenges, et cetera. There's also, along with the rule, a lot of guidance as far as like how to interpret the law itself. So I believe, hopefully I'm getting this right, but basically there's a rule and an order. So the rule basically is the thing that has the force of law, and the order is basically, how this law can be applied. Did I get it right so far? Mostly right? Okay, good. So before getting to the particular rule that was released last week, I think it's actually important to kind of step back and sort of see where this came from. I'm not going to go through all of this, but basically you might know this more, you may be more familiar with this in terms of net neutrality is basically the term that's where this is popularly known as. So about a year and a half ago, the Federal Communications Commission, the FCC, re-released an open internet order, which basically these net neutrality, these what's sort of popularly known as these net neutrality rules. I'll talk about what's in those, but this actually, why I'm talking about this and what this has to do with the privacy rule will become clear in a minute. What happened as a result of this rule actually gave the FCC, if we go back here, statutory authorization to start making privacy rules on ISPs. Okay, so what happened with this open internet order? That is again being challenged again, I guess, but is currently standing. Well, Internet service providers, well, something that the Federal Communications Commission calls bias. No bias there, of course. This is the broadband internet access service. So these are like Comcast, Verizon, AT&T, et cetera. Previously, they were classified under information providers, Title I, and the authority for those, I believe, was the Federal Trade Commission, not the FCC. When this order was put out in the latest order, there was a reclassification of ISPs under what's called Title II, which are telecommunications providers, which are essentially like the phone company. Okay, so now basically ISPs have moved from like one type of service provider, you know, akin to the Googles, Facebooks, et cetera, into a different type of communications provider, more like the phone company. What the order included in addition to this reclassification, the reclassification is actually important to where we're going with today's talk. There were a whole bunch of so-called bright line rules in the reclassification, transparency about the, you know, basically how traffic was being treated, et cetera. No blocking, no throttling, no slow lanes, no paid prioritization, so no fast lanes, and no unreasonable interference or disadvantage. Now, there are various exceptions that the rule makes, 400 pages, I won't read it to you, but there are exceptions about you know, reasonable network management practices. So if you look at throttling and prioritization and blocking, there's a lot of discussion still going on about when you have a lot of contention for resources, you know, limited network resources, what are reasonable network management practices. So that's basically all I wanted to say about the Open Internet Order. That was just kind of to set the table. Something that's sort of, you know, under the shadows of this whole net neutrality business is this statutory authorization that sort of came out of the reclassification. So a less discussed aspect of this Open Internet Order is that in these ISPs who are reclassified into telecommunications providers are now subject to provisions in the Telecommunications Act. Specifically, there's Section 222 of the Telecommunications Act, which now the FCC actually has statutory mandate to basically, for service providers that fall, that are telecommunications providers, they have to basically provide rules and guidelines about how those telecommunications providers are going to protect customer privacy. So this dates way back, right? So you can talk about basically, in the law, basically as written, at least to my understanding of it, a lot of it's written in the context of the phone company, right? So we'll see actually some examples of where relics pop up later on in the talk when we talk about outcomes of the existing rule. But this is sort of like, okay, your phone company gathers information about your address and, you know, billing, et cetera, and they're supposed to protect the privacy of that information. This section 222 is a couple pages long, and I've sort of excerpted parts of it here. Just the first section, the first subsection, if you will, that just gives you the gist of it, which is, you know, protecting the confidentiality of proprietary information, manufacturers and customers. So the customer thing is basically what sort of ticked off the whole discussion of the past year. They also talk about confidentiality of so-called customer proprietary network information, more affectionately known as CPNI. And that basically is all these things like social security number, your address, you know, birth date, et cetera, et cetera. We'll come to this again in just a few minutes because lots of discussions about what exactly this means for an ISP. For a telephone company, it's, you know, somewhat more clear. When we get to ISPs, it gets a little bit murkier. There are exceptions in Section 222, like when can ISPs, you know, collect and share this information with third parties, right? And they list out a bunch of exceptions, you know, things related to billing, protection of property rights, public safety. So there are things like location. You're not supposed to reveal the location of one of your customers unless, for example, they call 911 or something like that, and then you can obviously like reveal their location so that emergency services can get there and so forth. So there are exceptions like that. This one turns out to be relevant to the rest of today's talk. They also talk about sharing data about customers may be okay if we're protecting the rights or the property of the carrier or to protect users of the services. So this relates to security potentially. And I'll sort of, you'll see that aspect sort of pop up again. Okay, so that's sort of the context where this has come from. So we have the reclassification of the ISPs under Title II that basically gives the FCC sort of a statutory mandate to basically do something under Section 222 of the Telecommunications Act. Then the next question, of course, is what should they do, right? So this is going back to sort of the slide I presented at the beginning, right? So about 7 months ago, the FCC released what's this notice of proposed rulemaking, NPRM. They asked for comments about several aspects of several aspects of the proposed rule. Like they talked about things that they plan to say that ISPs had to protect. Related to protection of content. Obviously, what is content? Another one was sort of protection of CP&I, right? So we talked about these. Other things that sort of popped up were like, what is CP&I? Finally, there's a whole section in the proposed rulemaking, as well as in the rule itself, on data security, protection of this data, how ISPs are supposed to protect the data that they collect, and if there's a data breach, how they're who, when, and how they're supposed to do notification. I won't talk about this today, but there's a big chunk of the rule that's devoted to that. Good. So defining scope, right? Who's subject to this rule? So by sort of Title II, we would assume, or we sort of can assume that these bias providers, in other words, these ISPs, are subject to this. There's some discussion about that, and I'll come to that in a minute. But this is actually a more interesting question than it may initially seem from what I've told you so far. And the second is like, okay, when we get to the network, what is this CP&I? Like what, should IP addresses count? Should DNS lookups count? Should, there are 15 different ways to collect network traffic. So what counts as something that should be protected? Okay. So first, scope, who's in and who's out? So, nominally, right, your access ISP is in, people like this. Out, service providers of other kinds, non-bias, if you will, who are not under Title II, so Google, Facebook, Netflix, et cetera. Now, the FTC, these fall under the jurisdiction of the FTC. And this, in particular, I think is interesting when you look at the rule because there are a lot of references to the FTC in the rule itself in terms of justifying how, what kind of guidelines were set down.
Real quick,
yeah.
On that slide, is it basically one way to slice it is that in is where a customer doesn't have a choice, and out is where they sort of do have a choice. They can choose not to go to Google. They can choose not to go to Facebook, but if they have Comcast, they can't choose not to go to Comcast.
That actually is going to come up, yeah. So the only thing I meant here was like who's covered by this discussion at all. Okay, so one of the things actually that, but yeah, the opt-in, opt-out is actually a really interesting question. So when this notice of proposed rulemaking came down, the ISP said, hey, wait a minute, yeah, the FCC is considering these privacy rules, but this would, if the ISPs were subject to privacy rules that these guys were not subject to, then are we going to be at unfair advantage? And I think like one only needs to look so far as the news headlines about mergers to realize like the boundary between these is getting, murkier and murkier, and that certainly, came up in a lot of the comments and discussion. So I think one of the comments that ended and sort of the public comments that sort of came to bear certainly is that Paul Ohm, professor at Georgetown Law, had made many comments that suggested, well, the FTC model is in fact pretty reasonable for these people who are not covered under Title II, so maybe the FCC should use that kind of model. I'm not a lawyer, so I'll just leave some of that for discussion later, whether or not you've got some people subject to the FTC Act, another subject to this rule, and how that may play out over time, I think is an interesting question. But I want to kind of stick just to I'll use up my time just talking about the technical stuff. So I did submit comment on this. This was probably not where all the fireworks were, but I did actually talk about how exactly what you just said, which is basically, look, in some sense, these are apples and oranges, right? There's a lot of there's a lot of considerations related to like opt-in versus opt-out. Do you really have a choice? But really, what I talked about in my comment was like, what types of data do these different kinds of providers collect? What kind of data can Google collect? What kind of data does Comcast or Verizon have access to? How do they retain it? What do they use it for? Are they using it for advertising? Are they using it for network operations, security, et cetera? So that was sort of the gist of my comment there. But I want to focus on a different aspect of my comments today. So actually, to sort of talk about the rest, we actually have to go back in time. And this is interesting. It gives you, like, again, a little bit of a peek into, I guess, how this policy stuff works. So the rule came out. The notice of proposed rulemaking came out in April, but actually, going back in time, you'll notice there was some activity going on before that. So before the rule actually comes out, a lot of people know that before the notice of proposed rulemaking comes out, apparently there's basically pre-notice of the notice. So people know that the proposed rulemaking is going to be released, and the armies are already marshaling their soldiers. So in February 2016, Peter Swire, who's some people probably very familiar with here. He's certainly done a lot of work in national security. He's also a professor at Georgia Tech. He wrote a white paper. It's funded by Broadband for America, which is a coalition of ISPs. It's a trade organization, basically making a bunch of arguments that ISPs don't really see that much information or traffic about their customers. So this whole rulemaking thing is unnecessary. We shouldn't do it all. So at that time, I hadn't been paying attention to this at all. I sort of got sucked in, if you will. But someone suggested that maybe someone should basically reply to this, because otherwise, this is the only thing we have going. Then this would be maybe an unfortunate end of the story. So in March, beginning of March, I actually replied with a letter directly to the FCC chairman, and I'll talk about what was in that. So just briefly want to mention the types of things that were in the Swire report. So he put out this white paper. Main points he makes are that, okay, users are mobile. Okay, they move around a lot. So no single ISP might have a comprehensive view of traffic from a user. The idea being like, okay, you're at home, you pick up your laptop, you go to Princeton, you pick up your laptop again, you go to Starbucks. These are all different networks, and it's different upstream seeing the traffic. So nobody really has too much of a view of anything, right? Second one was basically about HTTPS and saying, HTTPS, being much more widely deployed on websites on the internet. In fact, like just recently, we saw, I think, more than 50% now of web traffic is HTTPS. So he basically put forth an argument that said, okay, more traffic is becoming HTTPS, nothing to worry about. The ISPs won't be able to see anything anyway. And the third point was basically about VPNs, saying, VPN usage being more common, more popular, and that as well will basically lead to, much broader, deployment, much broader pervasiveness of encrypted traffic, and make it much more difficult for ISPs to see things. So I read that, and this is sort of, I guess, where I first had a visceral reaction. I'll come back to that. So as a technologist, I read this, and I was not really understanding what I was reading. Maybe come back to that at the end. Thinking like, okay, well, this is certainly interesting. Doesn't really tell the whole story. So I sent the chairman a 3 or 4 page letter, basically kind of dissecting the report and sort of implying, basically stating that this didn't tell the full story. One thing I learned, by the way, is that I'll come back to this at the end. But some of the wording that I used in this, I guess easiest way to put it is the way that we write sometimes as engineers, certainly maybe not the same way that lawyers and policymakers often read things, and I'll come back to that at the end. But the point here basically is this sort of ticked off a much longer sequence or thread of discussion, and kind of got me pulled into orbit on this thing even more. I was getting a lot more phone calls, if you will. Here are some of the points that I made. I think basically anyone in the who knows something about networking can probably rebut those 3 points fairly quickly, right? So one thing. So obviously you can see these are the points. Some of the points I made in my letter. One of the things that that I probably should have clarified in the letter was that these are possibles, not necessarily probables, or certainly not known for certain. I got a lot of somewhat angry calls from ISPs actually when I filed my letter, suggesting that, hey, wait a minute, are you accusing us of anything? And I said, no. But yeah, so words matter. I'll come back to that.
No, but yes.
Yeah. So the second one, obviously, I think again, anyone who kind of is familiar with HTTPS knows that obviously, even if we take as a given that half of web traffic is encrypted with HTTPS, there are lots of things that still pop out in the clear, right? So the initial handshake, there's something called the SNI, which basically is contains the host name of the site that you're planning to visit. Also, DNS is not typically not encrypted, right? So even if your web session is encrypted, your DNS lookup is not. This actually became like a pretty lively debate, if you will. Lots of discussions among technologists and lawyers about, well, yes, this is all true, but all you can see is just the domain name. You can't see the actual page, and how much can you really learn from that? And I think Arvind, may have submitted some comments related to that as well, saying that even though web traffic is encrypted, you can often still infer the page. So this itself became like a very deep thread. A couple other points so this point actually I made, and then this was made in a different document, but I wanted to include it here. A lot of work that's being done around here, in fact, basically has found that IoT devices don't tend to encrypt a lot of the traffic in many cases, and with the increasing deployment of those kinds of devices, that's something we should be thinking about. Another point that another report made, another public comment made, that I'll talk about in a little bit more detail in a minute, is that you can talk about half of the sites, or half of the traffic, I think it was, but that does not say anything about what's in the tail. And one of the other comments made a point to this effect, which is that, sure, you can have encrypted YouTube, and that's great. No one can see that you're watching kittens do backflips. But with WebMD being unencrypted, which it was at the time, there was basically, it doesn't matter if, we shouldn't be counting bytes that are encrypted. There's lots of sensitive stuff, and often the sensitive stuff is in the tail. I'll kind of skip over this quickly, but I made a few points about how VPN usage is not really a silver bullet either. So that kind of went through. There was other folks who commented. This was turned out to be a very important comment as well. Upturn actually is founded by David Robinson and Harlan Yu. Some people probably remember them, former Princeton /CITP folks. And you can see sort of the 4 points that they made. So I'll just keep going. So that discussion all played out. That was kind of in April, and then actually at that point, in addition to the sort of ISPs saying, "Hey, wait a minute," there was this flip side of the coin that I was made aware of, and it definitely hit home. So here's the thing: is that customer traffic, right? In fact, our network traffic is often used for security, securing the network, detecting things like malware, botnet, spam, etc. For research, for innovation, testing new protocols, etc. And often these kinds of activities involve collaborations with third parties. So Arbor and VeriSign, they have DDoS detection and traffic scrubbing things, and those require often the ISP sending customer traffic through another network, right? Whereupon an appliance built by one of these folks is going to do inspection and scrub the traffic of the attack and send it back. Also, the Internet Engineering Task Force doing a lot of like new protocol development, et cetera. Vendors are actively involved, like doing things. And in order to basically test their new protocols, they often need samples, if you will, of real traffic, because how are you going to know if something actually works until you've tested it on actual traffic? So ISPs collaborate a lot with vendors through this standardization and implementation of those standards. So this was sort of a late-breaking realization, but it was basically that, look, if ISPs were prevented from sharing network traffic data like DNS entirely, then actually there might be implications for research. And this kind of goes back, actually, if you look at the Section 222 wording, which is why I kind of introduced that at the beginning as well, was, there are sort of these exceptions and potential carve-outs for security, basically the operation of the network, security, protection, et cetera, but they're not explicit, right? So this became sort of the lever that I ended up figuring out that where we could actually pull something and make something happen. So in the rest of my talk, I'll sort of talk about how I went from this realization to things actually showing up in the rule and order. So there are a lot of examples of this. Some of them are, I've listed, these are biased towards things I've done, but I think not to really just talk about my own, toot my own horn here, but really just to illustrate that, hey, wait a minute, there are a lot of research we've done in like, anti-spam and DNS abuse and looking at pricing of access networks and botnet detection, all of which rely on things like looking at DNS lookups from subscribers and looking at usage data, et cetera, often shared under non-disclosure agreements, like basically given to researchers by the ISP with the understanding that it's going to be used for this project and not shared. So, there's non-exhaustive summary of uses of, how customer data might be shared for good, third-party security services, research, and the protocol and device innovation that I mentioned. So now, okay, so there are these good things that can happen as a result of sharing, but how do you basically strike the right balance between, this need for, supporting research and also protecting, customer privacy? And then actually the thing that turned out the FCC was really worried about, with good reason, is, well, anytime you sort of create an exception, that's a chink in the wall, right? So how do you prevent that trickle, right, from becoming some flood? Like, how do you, like, what's a researcher, okay? And that became a fairly interesting exercise as well. So, how do you distinguish a network and security researcher from a market researcher, aka advertiser, right? So this was the big concern, right? And a lot of energy was spent on that. After my comment, I actually was asked to present at the FCC, and I'll give you like a little bit of, I might skip through a couple of these, like I won't give you the full details of my presentation, but I have most of it here. I was asked to come in and talk about exactly this, the two sides of the coin, essentially. What kind of data do ISPs collect? How do they use it? How do they retain it? What are the privacy risks associated with different kinds of data? So actually, before I went to the FCC, CITP and the Center for Democracy and Technology, we co-sponsored an event where we sort of, I think people were basically rehearsing and trying out their reply comments. So this included actually Peter Swire and myself and Harlan Yu, who wrote that report. So this was sort of the full cast of characters who'd been commenting really from academia and civil society on this particular issue of traffic, how ISPs collect traffic. So I'll talk a little bit, and basically what I talked about in this panel and what I talked about in the comment period. So I mentioned there's the rulemaking, then there's the comment period. So shortly after that panel, I filed a comment. This actually was probably 8 or 10 pages talking about exactly this question. What data do ISPs collect? How do they use it? how and when it might be shared with other third parties, if and when it might be retained, and to what extent this data contains things that might be considered CPNI, this customer proprietary, customer private network information. Good. So I did a presentation. This I'm not going to read to you because I'm going to show you the presentation, but this was new to me. Apparently, when you basically present at the FCC, you basically file a comment, like an ex parte, which basically says this happened, right? So this is basically to prevent people from going in under the cloak of darkness and trying to exert influence. So I found that kind of an interesting twist in the process. It was new to me. Okay, so here's basically the gist of what I presented to the FCC, which is really like a networking 101 kind of education, or maybe 201. But basically, what kinds of data ISPs collect, how they use it, when it might be shared, et cetera. Okay, so these are the types of, these are the questions that that I wanted to basically highlight when I talk to them. Good. So I started off by saying, let's assume that what Peter Swire says is true, right? That end-to-end encryption, protects certain aspects of your user privacy, et cetera. So from there, I basically said, look, even if we take as a given that that's true, there's still a lot you can learn from encrypted traffic. Reference Arvin's comments. Work on website fingerprinting of encrypted traffic streams, et cetera. And also, there are other things that people are visiting that are not websites. There are, apps and IoT services, et cetera, et cetera. Another thing I mentioned was, let's just take DPI off the table. So this was something that I think the policymakers, consumer advocates, et cetera, were talking about a lot. I found it to be, I found this to be a little bit of an educational experience because I found that to be not entirely constructive. The consumer advocates were basically saying, ISPs are basically a dragnet. They basically do packet capture of everything. They retain it forever, and you're owned, and this is terrible, and we need privacy rules. Okay, so I just didn't want to go there. I know this to be not the case because I've worked at ISPs, and just convincing the ISPs that they need to retain things for an extended period of time is a costly proposition because it's like storage. And yes, storage is cheap, but if you need to actually access it or analyze it, there's like a non-zero cost. And often it's the researchers or the people looking way out that are saying, hey, wait a minute, we want to look at that data, you should save it. And people are like, well, it's costing us X dollars to actually keep that. What's our, how's this contributing to our bottom line? Like, because this is just costing us right now. So this I thought was interesting because if you look at, say, the people who are, the organizations that are not covered by this rule, they are basically relying a lot on advertising, right? So Google's, Facebook's, et cetera. They have a real incentive to save a lot of this data. The ISPs, of course, they could be heading in that direction, right? Particularly with the mergers, and I think that's something that we need to be cognizant of. But this point, although hotly debated, what I decided to do is basically just step away from that. To say, okay, well, let's just sort of take DPI off the table. There are enough people talking about that, and I want to come back to that at the end because I basically saw, okay, there's this whole discussion going on over here about DPI. Let's talk about something where people are not talking about it.
Just the only question: what does DPI stand for?
Deep packet inspection. So looking at packet capture, looking at payloads.
Certainly.
Thanks. So what I did is basically say, yeah, everyone's talking about DPI, but like, what about this other stuff? Okay, so there's routing data. It turns out that's not that interesting in this case, mostly. But there's this other stuff, NetFlow or IPFix or what have you, domain name information, SNMP, et cetera. Turns out most of this stuff is not entirely relevant to CPNI, but I wanted to be exhaustive to say these are the kinds of things that ISPs collect, and these are how they might be used. So I'm going to skip for time. I'm going to skip over the ones that are sort of not particularly relevant, like the routing data, and just skip to traffic data. So what I did was basically give a tutorial about like other types of traffic data that ISPs collect, how they use it, and where we might be concerned privacy-wise. So many people talk about something called NetFlow, which is actually a Cisco product, right? So instead of Kleenex, we want to talk about tissue, tissue paper, right? So the tissue paper term is IPFix, right? So this is basically statistics about like these flows existed in the network, and this is from, to, how long, et cetera. I'll talk about that in a minute. DNS and then SNMP, which is also less relevant. But so IPFix actually turns out to be really interesting use case, right? Because this is heavily used by Arbor Networks, VeriSign, lots of startups, et cetera, for detecting malware, botnets, traffic anomalies like failures, et cetera. Also, they use it for performance, right? So trying to figure out basically what's the utilization on a particular link. Also used for sometimes looking at anomaly detection. So you can figure out whether or not you have a denial of service attack or a link failure or something based on sudden changes in traffic volume. Okay, so this data is kind of useful for operations and security. It's often shared with third parties. It's also often shared with researchers, and I gave some examples of that earlier, so I won't get into the details of that right now, but I talked a little bit about how this data is shared. Then I talked a little bit about, like, okay, what are the risks when this data gets shared? So, and this again, I think, comes to the point of, like, even if we assume end-to-end encryption, there's other stuff in this other data that, you know, we should be concerned about. So these records, they contain information about where is a particular, you know, here's a customer IP address. What IP addresses is that customer talking to? How much activity is there, right? So if you want to figure out, oh, is this person home or away, or you know, are they visiting a particular website a lot, right? Some of that data is pretty, some of that activity is very evident even in this quote-unquote metadata. Applications, right, often can be detected as well. Of course, if you know anything about networking, you know, like these days almost, you know, lots of stuff goes over port 80 and 443, the web ports. But still, based on, for example, the traffic rates that we see, right, and how much traffic, as well as the IP address, the destination IP address, we could maybe figure out, this is Netflix because it's, you know, it's exhibiting a particular traffic rate and it's going to this content distribution where I know, you know, Netflix to be serving traffic from. Good. So I'm going to skip over like a couple of the other examples, but I talked about, you know, how in IoT settings and, you know, just even simple like on-off patterns, you can tell basically things that are incredibly privacy invasive, like figuring out whether users are awake or asleep, et cetera, et cetera. So you can do that even from this metadata. DNS, I won't so obviously bore you with how DNS works, but I did sort of talk about that with the FCC. Again, this data gets collected and it's used in a bunch of different ways. So there are various ways that it's used for load balancing, right, to basically try to figure out where client traffic is going. There are, this is a little dated, these guys are defunct now, but lots of other companies doing this as well, where they're basically relying on DNS lookups to figure out, is there an infection? So this is DNS traffic really useful for signal for things like infection, because often a DNS, you know, device will issue a DNS lookup to some place it's never looked up before. And often it's a gobbledygook domain if it's a botnet command and control, or it could be some, you know, thing that's clearly a phishing domain, like, you know, Facebook with, you know, 2 O's and a 0 or something, right? So a lot of companies have basically built security appliances that look for fishy or wacky domain names to indicate that that there may be a compromised device. Again, this DNS data often sent off-site, or at least, you know, to the under the sort of purview of that third party to actually do that kind of detection. Good. So and there are other sort of things that are done with DNS with security as well. Of course, probably don't need to tell you that there's just tremendous privacy risks with DNS, right? So you can figure out which sites the user's visiting, potentially what kind of devices users have in their home, as well as how they're interacting with those devices. So, myself and many of my students have worked on various aspects of that, both sides of the coin actually, both anomaly detection and attack detection with analysis of DNS traffic, as well as sort of what you might call activity monitoring or detection. So there are definitely two sides to this. So I talked mostly about this already. So I'll just kind of come to the summary, right? So there are legitimate uses to a lot of this data. I basically mentioned we should be looking beyond deep packet inspection. Each of these, that I talked about poses, various privacy risks, and it's important to kind of understand how this data is used and what the risks are to sort of make the appropriate recommendations. So I did that, and then I filed all of this in, reply comments. At this point, I actually marshaled a whole bunch of people from the community, and this is a mix of computer scientists, networking, and security researchers. You may recognize some of the people on this list, myself, Jen Rexford here, Mike Bailey, who's a security researcher at Illinois, Manos Antonakakis, who's a security researcher at Georgia Tech, and then some, Maka Petras, you may have heard of him, he invented DNS. This was an interesting exercise because we marshaled this, and then we the FCC said, thank you for your presentation, please tell us what to do. So this is like great news, right? Because they're listening, right? They said, okay, thank you, now what should we do? And this became like a little bit, I think, basically a brief foray away from the technical into the sort of political cat herding kinds of exercises. And what we did with that group of people that I just mentioned was to start crafting proposed language for what a researcher exemption would look like. And this was actually a huge learning experience for me, just trying to basically write by consensus for, among like 10 people where everyone has their pet kitchen sink thing project that they want to throw in. Oh, I've got this thing involving ethics, and we should throw that in. And oh, I've got this review board that I sit on. Let's shove that in. And it basically took a lot of like cat herding and saying, thank you for your input. Here's what we're trying to do. If we throw all that in, this is all going to get thrown out. So let's be serious. So this was a really useful lesson for me as far as like how to kind of like write one of these things in a way that reflects consensus, but yet keeps everyone happy without necessarily having to like put everything in that everyone wanted in there. So this took like maybe a month for about 2 pages of writing, but we did come up with basically a proposal for the types of things that should be exempted and under what criteria. Yeah.
Sorry, did you mean that your
Reached, sorry.
Okay,
Yeah, sorry about that.
That was another
Sorry about that.
okay.
No. Yeah, we reached it, sorry. Clearly I had my head in research here. So, it's just that the types of, basically the criteria that we came up with, all this did not make it into the rule in this form, but like I'll show you some of the things that did. So we talked about basically what's the purpose of the research, right? The purpose of it should have to do with these things that the FCC should care about, and already 222 is in principle already exempting through that language I showed you, right? So things related to security, stability, and reliability. And this resonated, I would say. Oh yeah, they said protection, we're good. We agree that should be not covered in the scope of the rule. Obviously, the research itself should not involve like developing new ways to violate user privacy. The third one is really this was contentious actually between folks who basically were versed in more ethics, where we're sort of used to thinking about things like beneficence and risk-benefit trade-offs, versus some other folks who are more on the might say litigiously oriented side, to say, hey, this is really you're opening basically a loophole here for litigation, because how are you going to argue about risks and benefits? So I think whether you're an ethicist or a lawyer, I don't know, maybe you're both, but like certainly there's this was contentious, even in like reaching consensus in this document. Then we talk about basically added value and attempts to mitigate risks. Yeah.
Did you talk about about the who question?
Yeah.
How
So.
to think about who constitutes a research?
Yeah, so we tried to basically do that as well, and they said, okay, yeah, this is the next slide. So it's like, okay, who do we think this is? And this again was tricky right? So we did give some examples here. I think basically, I think we did a pretty good job, but like you can imagine here, like this is a tricky one, like walking the line between, actually any of these, right? You talk about what's industrial research, right? And then, okay, we want to kind of give some examples of things we think are good and, you know, with the implication that other things might not be. And here too, right, I think these are meant to be exemplars, but not necessarily like, oh, if you're in this category, like you're definitely okay, because I think any of these, there are things that go over the line. Okay, so we filed this comment in August, and then just at the end of October, we saw this in the Washington Post. This was like 2 weeks ago, I guess, and the research exemption was not discussed too much, but that's why I figured I'd talk about that today. So this is really all about consumer protection. I'll talk about what's in the rule in just a minute. This is really interesting because I saw this and I was like, great, where's the rule? And apparently the way things sometimes happen is the press release comes out before the actual text of the rule, and I asked some folks, where's the rule? And they said, oh yeah, we're still writing it. You know, so again, like basically a week later, we finally got to read the rule. So I read it at the end of last week, and I'll give you a couple highlights. I think it's really kind of edifying to see, you know, the final text of the rule and sort of what ended up showing up in certain parts. So if you look at like, you know, there's a whole section on what is customer proprietary network information, and they talk about a bunch of things here, citing a whole bunch of comments. And I found this like particularly edifying because that basically ended up showing up as like, yeah, this matters, like we should care about that. Also, there are a couple of other things that are, you know, there's all this stuff is discussed in like, you know, really extensive detail. They define a bunch of terms. I actually had to ask a lawyer to help me figure out what all these meant. They talk about customer private information, which is basically the CP&I thing, plus some other thing that they call, I forget what PI is, personally identifiable information. They use something else even, I think it's private, but anyway. Basically here, they make a lot of reference to the FTC rule. So I thought that was kind of interesting, you know, having followed the whole thing from start to finish and seeing other people comment, to see such extensive reference to the FCC rule is pretty interesting. Also, the rule makes extensive citation of Arvind's comments on de-identification and, you know, what is possible even with encrypted traffic. So that's all in there. Another thing that actually is interesting, just coming back to these rules were originally written for telephone companies, right? And there's an exception in Section 222 that talks about phone books, right? So you can publish, you know, people's phone numbers if they show up in a public directory. Okay, so they do have like an interesting, you know, sidebar, if you will, you know, several-page sidebar on how, you know, they don't think that this necessarily applies to ISPs, right? You shouldn't necessarily be publishing, you know, usernames or, you know, real names and IP addresses that they map to. This interesting example of how, you know, when a rule is written for one regime and then certain companies or service providers get dropped into that regime, not everything necessarily carries over. So these are some highlights on, you know, who's protected. This I think was really important, right? So they talk about, you know, informed consent, opt-in approval for the use of and sharing of private information. So basically, if you're not a researcher or one of the people covered by the exemption, right, you know, the data is not being collected for those purposes, you basically have, the ISP has to ask the customer, and it's opt-in, not opt-out. So by default, the ISP now cannot collect any of that information that I just showed you without notifying the customer and giving them choice, unless it's for one of these exceptions that I mentioned. So exceptions, so this stuff actually did show up here. So research actually ended up showing up in the rule itself, and you know, there we are quoted. So that I thought was very edifying to see. This I think is really important here too, right? And this comes to ethics and IRBs and other things like that. One of the things that we had a lot of discussion on when we wrote the consensus letter was, should we explicitly talk about IRBs? Because as we know, IRBs are not a silver bullet. You know, a little bit of and certainly there are people in some of those categories, like industrial research, they don't have institutional review boards. So we ultimately said, in the comment said, and IRB is an example of this, but I think they did a pretty nice job abstracting that away to something that's general enough and yet gets the point. So network management comes out as sort of an exception. Another exception that comes out, right, is security, and that should come as no surprise because it's sort of already in 222, and also this is something that we asked for in the comments. So, and again, it's exactly the kind of things that we talk about in our comments, like spam and viruses and what have you. So that's kind of the outcome. I guess now we'll see what legal challenges come, and we'll have to, now we're in like step 3 of that 5-stage pipeline. I just wanted to close with like some broader takeaway lessons. One is that sort of this is not something that basically, I think as engineers we're used to thinking about super hard, but like words really matter. Definitions are really hard, like defining researcher. We spent a really long time on that. Another thing that I alluded to earlier is coming back to the original letter I wrote back in early March. As computer scientists, we read these things and that are written by people, and we say, this is totally like wrong, basically, because he's left out all these things, and here's some points I'd like to make. And you got to be really careful about the words you choose, because people who basically write words for a living know how to read these things and find the weakest link in your argument and say, you used this word, but actually you probably didn't mean that. Like, so let me now zero in on this one sentence that you didn't choose your words carefully enough. And then after that letter, I basically, had to backtrack a bit and say, no, like I did use the word incorrect, but I didn't mean incorrect. I just meant didn't tell the whole story, incomplete, And what basically I conflated, disingenuous omission of the full story with something that was basically not correct. So I think this basically was a really important lesson for me, and probably anyone who wants to participate in one of these processes is think hard about what words you use. And I actually had a good discussion with Peter about this later, which is he always has other lawyers read his comments and et cetera before filing, and that's something I should have done before doing this, because certainly you don't want another lawyer who you're trying to argue with be the first lawyer to read your comments. So the consensus, I talked about sort of the difficulty of building consensus, and like everyone's like, oh, there's a high stakes thing and there's a rule being made, and let's like shove my favorite thing into the comments, and sort of that was a real challenge. I think the other thing that I learned from the process was pick your battles, like preferably ones that you can win, and also ones where you can offer something unique. So I kind of gave you the full arc of the story, which was like, we started off talking about like this, the Swire paper came out and started off in a discussion about like, sort of everything that was left out of that paper, and where we ended up was somewhere completely different, which was like, we were basically writing exemptions for researchers. And the way we ended up there, like we never would have done that in the first place had I not started where I did, but basically just paying attention to like who's pushing you and who's pulling you, and you basically see, okay, well, actually you got someone's attention, but this is something that like the FCC wants, and the ISPs want, and researchers want, and other parts of industry want, and I identified it as something where like we could win, like we could write comments and provide input, and people would listen, and also it was an area where I saw that basically I was rare, right? So you want to kind of go into areas where you're rare. And when everyone over here is like talking about DPI and ISP dragnetting and this and that, and nobody's talking about IPFix and NetFlow and DNS, then that provided an opportunity to say something really unique and different. And that was certainly an important part of it was an important lesson I took away. So hopefully this was useful just in a couple ways, both just like providing an overview of like what the context of the rule, but also I think for the technologists in the room like wishing to engage in this process, I think I will certainly reiterate that I found the process to be a tremendous learning experience, but also very valuable. This was something that
when I was called in March to basically write a letter, I was like, what? What's CPNI? Like, what's going on? Sorry, like, I'm doing my security research. Like, please leave me alone. And it was one of these things where often what's being discussed and, you know, where rules and laws are being made that could actually affect how the internet works and how research works, we're not often by default included in those discussions, but we need to be. And it's definitely a different process than those of us as computer scientists are used to engaging in. It can be quite frustrating in a lot of ways. It's certainly a lot slower in many ways, but certainly I think this was an example where in the end I felt very positive about the impact that we were able to have. And I hope that, you know, since this is the Center for IT Policy, people will take my talk, you know, to heart and, you know, pay attention when the FCC or the NTIA or the FTC is asking for comment, because there are plenty of chances where, you know, as technologists we can have input into these processes and really make a difference. So thanks.